Hello everyone, this is Meenakshi Dilip Birari, working as an assistant professor in chemistry at Maratha Vidya Prasarak Samaj, Nasik. As in previous lectures, we have received fair information about intellectual property right, copyrights and trademarks. Now, in today's lecture, we will learn about what is patents, types of patents, conditions of patents and criteria of patentability. So let's begin. As we know, IP rights can be further classified into following groups. These are copyrights, trademarks, patents, trade secrets, industrial designs and geographical indication. So these are the typical methods of protection. We will study first three types in detail. Already in previous lectures, we have discussed about copyright and trademarks in detail. Now, in today's lecture, I am going to discuss about one of the intellectual property right, that is patent. So first of all, what is patent? How we can define patent? The original word patent is derived from Latin term, that is patere. It means to lay open or to make it available for public inspection. Patent is a grant from the government, a guarantee for a limited period of time, the required privilege for making, selling and using the invention. So we should remember that patent is the word from Latin term patere. It means to lay open or to make it available for public usage. Patent is a grant from the government, a guarantee for a limited period of time and the required privilege for making, selling and using the invention. We can define in other words patent. A patent is an exclusive right granted by a country to the owner of an invention to make, use, manufacture and market the invention, provided the invention satisfies certain conditions stipulated in the law. Now here the word exclusive right. What is exclusive right? Exclusive right, that means the right given to only a particular person, entity or group. It implies that no one else can make, use, manufacture or market the invention without the consent of the patent holder. So in the definition of patent, also this word is there. A patent is an exclusive right granted by a country to the owner of an invention to make, use, manufacture and market the invention. That means the right is given to applicant or to the inventor to make, use and manufacture and market the invention, and it is granted by a country only to the owner of an invention. This right is available only for a limited period, that is for about 20 years. So we should remember the definition of patent. Simply it is nothing but an exclusive right granted by a country to the owner of an invention to make, use and manufacture and market the invention, provided the invention satisfies certain conditions stipulated in the law. Importance or significance of patent. Patent encourages research and development. It induces an inventor to disclose his invention. It stimulates capital investment. It encourages technology and development. It encourages establishment of new industries. So these are nothing but related things with significance of patent. Why the patent is necessary are also same. Importance or significance of patent. We should summarize it. It induces an inventor to disclose his invention, encourages technology development, to encourage research and development, encourages establishment of new industries, stimulate capital investment, affects economy. So these are the points related to importance of patent or significance of patent or why the patent is necessary. Why to go for getting patent or what is the need to get patent? To enjoy the exclusive right over the invention, to ensure commercial returns to the inventor for the time and money spent in generating a new product, to protect invention and proceedings. So patent is important to enjoy the exclusive right over the invention, to ensure commercial returns to the inventor for the time and money spent in generating a new product, and also to protect invention and proceedings. It is important. The need of patent are also why the patent is important. To protect the creativity of individual, to protect their invention from being copied, and to reward the inventor. To get a patent, it is necessary. Now, what are the conditions of patentability? Patents may be granted for any invention concerned with the functional and technical aspects of products and processes. To qualify for patent protection, the invention must fulfill the so-called the conditions of patentability. Now, what are the conditions of patentability? First one, novelty, inventive step or non-obviousness, industrial applicability or utility, and patentable subject matter. So these are the conditions of patentability. It should be new or novel. That means the invention should not be publicly known in any way, anywhere in the world. It should be novel. Then inventive step or non-obviousness. The invention must be an improvement over any existing product or process that is already available. Industrial applicability or utility. The invention must be useful and have some form of practical application. It should be capable of being made and used in industry. And last one, that is patentable subject matter. It should have patentable subject matter. So these are the 4 important conditions of patentability. We should summarize this: patentability criteria and conditions of patentability. Novelty, it should be new or novel. The invention should not be publicly known in any way, anywhere in the world. Non-obviousness, that is inventive step. The invention must be an improvement over any existing product or process that is already available. Industrial application, that means the invention must be useful and have some form of practical application. It should be capable of being made and used in industry. It should have industrial application. So these are the 4 important conditions related to patentability and the criteria of patentability. Now, what are the types of patent? Patent is mainly classified into utility patents, design patents, and plant patents. Utility patents, it covers anything having an actual use. It is a patent which covers anyone who invents a new and useful process. For example, machines, processes article of manufacture or compositions of matter. Second one, design patents. It cover ornamental product designs. Third, plant patents for distinct and new varieties of plants that have been invented or discovered and asexually reproduced. So these are the three types of patent: utility patents, design patents and plant patents. Utility patents cover anything having an actual use. Design patents cover ornamental product designs. It includes original or ornamental design for a manufactured product. Plant patents for distinct and new varieties of the plants, and it is a patent related to a kind of plant which is capable of reproduction. So these are the types of patent. What is patentable? The Supreme Court has said that patents cover anything under the sun that is made by man. It must fall within 5 statutory classes: processes, machines, manufactured items, that may be objects made by humans or machines, compositions of matter, and new uses of any of the above. So that is nothing but patentable matter: processes, machines, manufactured items, compositions of matter, and new uses of any of the above. Non-patentable subject matter. It includes any artistic creation, mathematical formulae and algorithms, naturally occurring organisms, laws of nature, abstract ideas, natural phenomenon, treatment process. So these are non-patentable subject matter. Harmful inventions, anything prohibited by the national patent laws. So all these are nothing but non-patentable subject matter. So you can see that 9-year-old boy that is having the name Hridayeshwar Singh Bhati has got the patent of design of a game of 6-player circular chess. Hridayeshwar Singh Bhati is the youngest patent holder. A Jaipur-based wheelchair-bound 9-year-old boy, Hridayeshwar Singh Bhati, youngest patent holder. The Patent Act 1970. According to this law or the Act in 1970, the definition of the patent is given, that is again exclusive right for being the true and first inventor of a product or process granted by the government for a limited period to exclude others from making, using, selling or importing the patented product or process without his consent in exchange of full disclosure of his invention. According to Patent Act 1970, a patent is exclusive right granted to a person who has invented a new and useful product or process. For example, high power argon or nitrogen transfer laser invented by Bhaumik Mani. Or also Sir Abraham Lincoln received a patent for flotation device. The exclusive right is territorial. That means the patent is granted in India, is valid in India only, and for limited period, that is for about 20 years. During the term of the patent, the patentee, that is the owner of the patent, can exclude others from making, using, offering for sale or selling their invention throughout the territory. That is again India for Indian patent. or importing their invention into territory. The patent is granted in India, that is valid in India only. So it is exclusive right, it is a territorial. Patentee or the owner of the patent can sell, assign and license to others to use or exploit his patent. So all are included in the Patent Act 1970. The patent system adds the fuel of interest to the fire of genius. It is said by Abraham Lincoln. Now what are the patent expiry modes? When the patent expires. The patent has lived its full term, the patentee has failed to pay the renewal fee, or the validity of the patent has been successfully challenged by an opponent by filing an opposition either with the patent office or with the courts. So these are the three conditions to expire the patent. As soon as the patent expires, it passed to the general public domain, and now anybody can use it without the permission of the original inventor. The patent is valid only for about limited period, that is for about 20 years. So as we have studied the intellectual property rights, copyrights, trademarks and patents in detail, what are the types of patents, conditions of patents, criteria of patentability in detail in today's lecture. Now in next lecture we will see the next topic in detail. Thank you.